Good day, Crime Talk aficionados. This is Crime Talk, and my name is Scott Reich. Let's do a quick preview of the docket. First, things are about to get real interesting in the Murdaugh case, and I will tell you why. Next, some legal gymnastics for a delay in the former Minneapolis police officer's trial that was scheduled to start. Josh Duggar, guess what? No kids for you, no internet for you. I'll explain. Be careful who you share your location with. It could be a deadly mistake. Do cops have a duty to save a knucklehead? And then finally, our dumb criminal of the day. Let's talk about it. Good day, Crime Talk aficionados. You know the drill. Subscribe if you have not. Like the video if you do. Leave me a comment and hit that bell so that you receive notifications when we go live or put up new content, which is a good time to remind you that tomorrow night we will go live 6 p.m. Mountain Time right here on YouTube. Now, remember, you can listen to us on your favorite podcasting app by simply searching Crime Talk with Scott Reich. Listen to all of the past episodes of Crime Talk. Lots of interesting stuff there. Go check it out. First on the docket, things are about to get real interesting in the Murdaugh case. Alex Murdaugh's attorneys have failed to convince a United States District Court judge that any further release of their client's jailhouse calls would be considered a violation of federal wiretapping laws. Well, the court's order denies Alex Murdaugh's request for a preliminary injunction and now puts the ball in Richland County's court to make good on its promise to release the calls upon this very decision. Now, the jailhouse calls were released earlier this year and directly contradicted statements made by the attorneys that said Mr. Murdaugh was broke. In a 20-page order issued on June 1st, United States District Court Judge Cameron McGowan Curry denied Murdaugh's request for the preliminary injunction. Murdaugh's attorneys filed this lawsuit in the United States District Court based upon leaked jailhouse tapes. That's because the South Carolina Freedom of Information Act allows for the release of inmates' phone calls, which are recorded. Inmates and the individuals that are receiving the calls from the inmates are clearly made aware that their calls are being recorded. In fact, Murdaugh reminded family members several times during the calls that they were being monitored. Murdaugh's calls were also cited in the South Carolina Attorney General's memo in opposition to Murdaugh's request for bond reconsideration in January. Now, the vast majority of inmate calls would be of limited interest to the public. It is clear that the Murdaugh case is a wild exception, particularly as it relates to transparency. Judge McGowan Curry notes that her order is based solely upon Murdaugh's attorney's federal wiretapping law argument that Murdaugh was not seeking relief for the Freedom of Information Act request. She mentions that the calls might be exempt from release under state law, which in part allows for the non-disclosure of law enforcement information that would deprive a person of their right to a fair trial. However, it would be difficult for the attorneys to claim this exemption based upon their own nationally televised admissions of their client's guilt, where they said that he basically stole millions of dollars from clients and his law firm. Now, the argument under the federal law was that anything regarding a tapping of a telephone line needs to be approved versus Title III of the federal wiretapping statutes. The court completely rejected that argument, basically saying the Murdaughs and anyone else in the jail are clearly warned that these can be turned over to law enforcement. In this particular case, the Freedom of Information Act allows that the tapes be turned over to the public. That was the problem that the Murdaughs had, saying that, yeah, we know the police would be listening, but we didn't know it would go out to the world that these calls could in fact be released. Now, take it from somebody that has listened to a lot of jailhouse calls over the years. Most of these will be boring. Some will be completely embarrassing. And there'll probably be lots of admissions. And what does this prove yet again? It probably will show that no one ever listens to their attorney when the attorney advises them, do not talk about the facts of your case or your case on the phone in the jail with anyone, because anything you say can and will be used against you. Somehow people only think that what is actually stated to law enforcement is the only thing that can be used against them. No, that is not the case. Anything a defendant says, as long as it's relevant, can be used against him in a court of law. People don't seem to get that, including jailhouse calls. I think things are going to get real interesting, because when are people most candid? Well, when they think no one is listening, or at least when they think no one's actually going to want to listen to my jailhouse calls. So things are going to get good in the Murdaugh case here real soon. I can't wait to hear a lot of these calls. Next on the docket, some legal gymnastics for the judge to grant a delay in the case for the former Minneapolis police officers. The Minnesota judge who presided over the murder trial of former Minneapolis police officer Derek Chauvin has pushed back the trial dates of the two other former police officers charged in George Floyd's death. Judge Peter Cahill agreed to move the trial date of Tao Tao and J. Alexander Koenig to January of 2023, apparently as a way to diminish the effect of the pretrial publicity. Now, this comes 1 month after the fellow former officer Thomas Lane pled guilty to the manslaughter charges against him, and months before that, Lane, Tao, and Koenig were each convicted by a federal jury of civil rights violations. Now, although Judge Cahill denied a defense request to move the trial out of Hennepin County, he said publicity surrounding the Lane guilty plea and the federal convictions this close to the scheduled June 13th trial date is particularly troublesome and does create a reasonable likelihood of an unfair trial. The judge also wrote, finally, and most importantly, the court is satisfied that a fair and impartial trial can eventually be had in Hennepin County, the most populous and diverse county in the state, putting eventually in bold. Now, Tao and Koenig's trial will begin January 5th of 2023. Motions in limine are set for January 5th and January 6th. Jury selection will begin on January 9th. Opening statements will commence probably about January 30th. And finally, Judge Cahill said that he would not accept any negotiated plea agreements unless a change of plea hearing is scheduled not more than 15 days after the sentencing proceeding in Tao and Koenig's federal case. So what does this mean? Well, as you may recall, Derek Chauvin, obviously nobody here is a fan of Derek Chauvin, but we would like everybody to get a fair trial. And as you recall, many of those same arguments that these officers made to have their case moved, pretrial publicity, the fact that the matters had been in the news, those were insufficient for Mr. Chauvin to get his trial moved. But yet, apparently, it's okay in this particular case because the court wants to set it out after the federal sentencing to see if there's going to be a disposition in this particular case. And as the court notes, he's not going to accept any guilty pleas unless they are actually done 15 days after the sentencing proceedings in federal court. Now, ladies and gentlemen, we've told you lots and lots of times here on this show that the law should look at the facts, apply the facts to the law, and come up with the result that the law dictates, not the result that you want to have. This is an example of the court engaging in legal gymnastics to get to the argument, the end of the argument, the conclusion that he wants, which is to delay the trial instead of starting it here in the next several weeks. All these arguments were rejected by the court previously for Derek Chauvin, but yet now he's concerned about pretrial publicity for the officers who, yes, clearly have already been found guilty in federal court, and here they are in state court. It just seems a little disingenuous to me. But hey, guess what? That's what the courts do oftentimes. And I really like the judge in that particular case. I think he gave a good trial to Derek Chauvin. But the reality of it is here, he's getting to the result he wants, not the result that the court should have come up with, which is, let's start trial. Josh Duggar is currently serving his 12-year prison sentence for possession of those inappropriate images regarding minors. And we now know what it will look like when he is released after he serves 85% of his 12-year sentence. That's right. He is not to have any unsupervised contact with minors, including his own children. So most of them will still be young teenagers when Mr. Duggar is released, which is a good call and not surprising in any way whatsoever. If he does want to see his children, guess what? It needs to be supervised by at least his wife and parents or another adult that's actually been approved by the United States Probation Office, which usually means that they have to acknowledge the guilt of the party that is there so that there's an appropriate action plan, safety plan in place to be followed in case Mr. Duggar comes in contact with children that should not be there or he should not be around. And additionally, Mr. Duggar, shockingly, cannot access including adult sites, and he's frankly banned from using the internet without prior approval from his probation officer. So Mr. Duggar will be sent back to the dark ages, not being able to have access to the internet whatsoever because, well, frankly, got some impulse control issues and downloads inappropriate images. That's just gross and, well, good for them. He'll also have to follow the more standard supervised conditions of release, which include sex offender therapy, and will have to submit to a lie detector test if asked by the probation department and his sex offender evaluators. Now, Mr. Duggar's attorneys say that they plan to appeal the conviction as well as the sentence. We'll see how that works for Mr. Duggar. We'll see if we're still here in the next 8 years talking about Mr. Duggar. Hopefully, I guess. Hopefully I've quit my day job by then. Wouldn't that be nice? All right, next on the docket. Be careful who you share your location with. Okay, this could be a deadly mistake. We've all done it. We've let people know where we are through some sort of tracking device, right? Well, a woman in Indiana allegedly tracked down her boyfriend at a bar with an Apple AirTag and ultimately wound up killing him by running him over 3 times with her car after she saw him with another woman. Turned out the woman was his sister. Just kidding. Just kidding. Galen Morris, 26, allegedly hit her boyfriend, Andre Smith, also 26, with her vehicle around 12:30 a.m. on June 3rd in the parking lot of an Indianapolis pub called Tilly's. Now, officers arrived at the scene to find Mr. Smith laying on the ground underneath a vehicle. The officers pronounced Mr. Smith deceased at the scene. A witness told officers that Morris was in a relationship with the victim and thought he was cheating on her with another woman. So she tracked him down with the AirTag to Tilly's. It's a logical thing to do, is it not? And it's an Apple AirTags. They're corn-sized devices that can be attached to keys, backpacks, purses, and other items to help people track them down via iPhone if they're misplaced. Now, when she arrived at Tilly's, she allegedly grabbed an empty wine bottle and swung it at the other woman. Moments later, they were asked to leave by staff. A witness later shared with police that she was at a bar when she saw Morris pulling forward and clipping Smith with her car in the parking lot. Now, Morris then allegedly attempted to run after the woman after exiting her vehicle, but police intervened and placed her under arrest. The woman that had initially been at the pub with Smith was not harmed in the incident, and Morris is behind bars being held at jail on the charge of murder. The prosecutors will assess the charge and whether additional charges will be filed. All right, next on the docket. Do police officers have a duty to save a knucklehead? You let me know if the police officers were wrong, maybe okay, right, should be disciplined, maybe fired, or charged criminally. This is an interesting one. So police officers in Arizona were responding to a reported disturbance between a couple near Elmore Pedestrian Bridge in Tempe, Arizona. Sean Bickings and his partner denied that any physical altercation had occurred when officers arrived just about 5 a.m. The officers then told the couple that they were running their names to check if either one of them had any outstanding warrants when Bickings climbed over a 4-foot fence towards the water and dove in. "I'm going to go for a swim," Bickings said in the body cam video. "I'm free to go, right?" The cops told Bickings that he was not allowed to swim in the lake as they stood on the other side of the fence. Bickings can be seen taking a few strokes out from the shore, and one of the officers asked the others, "How far do you think he's going to be able to swim before the video ends?" Well, the Tempe Police Department didn't release the entire video because they said that the actual drowning was a little too sensitive for viewers. Now, in the transcript, Bickings tells the officers that he's drowning, and they tell him to swim over to the pylon and grab hold of it to keep himself afloat. He responds, "I'm drowning." "Come back over to the pylon," one officer responds. Mr. Bickings says, I can't. The officer then replies that he's not jumping in after him. Bickings begs the officers for help, saying that his feet can't touch the bottom of the lake. Bickings' partner also pleads to the officers to help. One of the officers threatens to put her in the police car if she doesn't calm down. Now, the woman replies that she was trying to calm herself but was getting emotional because she loved Bickings and cared deeply about him. At least one officer attempted to get a boat to rescue Bickings, but it was too late. Now, Bickings went under the water surface and drowned. Now, it's unclear how long he was underwater before he actually drowned, and his body was recovered from the lake at about 11:20 a.m. So several hours had passed by. So the Scottsdale Police Department of Public Safety is investigating the incident and the police response. The 3 police officers who responded to the disturbance call and witnessed the drowning have been placed on paid administrative leave pending the investigation. So the question I ask you is, should those police officers done a little bit more? Now, if that was you or me standing next to the side of the lake and somebody says they were drowning, we have no duty to go in and save them. But then again, we're not public servants there to protect and serve. Now, in this particular case, Mr. Bickings, trying to be cute, when the police officers were running their IDs for any wants or warrants, says that he's free to go and states that he's going to go for a swim. Well, apparently Mr. Bickings, not being the accomplished swimmer that he thought he was, drowns. And the police are like, well, touch the bottom, go touch the buoy. And he doesn't do anything. He drowns. Should they be held responsible? Is Mr. Bickings responsible for his own death? Should they have been required to jump in and save Mr. Bickings? Or is it just a little bit of case of social Darwinism taking effect here? Let me know in the comments what you think should happen to the officers, if anything. All right, and our dumb criminal from last week, Tony Dominique, he ignored the Iberia Parish Sheriff's deputies instructing him on the need to get permits to move a house, and while pulling the oversized load down the road, he hit several mailboxes, road signs, and trees. And finally today, our dumb criminal. A driver in Florida was driving distracted and crashed their SUV head on into traffic. The driver was reportedly receiving intimate services from the passenger when he crashed the car. The driver crashed into a FedEx vehicle in Fort Lauderdale that resulted in injuries to his private area. Neither occupant of the FedEx vehicle was injured. The only package harmed was the one being attentively gift-wrapped by the passenger of the SUV. Some aerial footage of the aftermath showed both SUV occupants being treated at the scenes, pants around their ankles. You can't make this stuff up, ladies and gentlemen. And I defended somebody in a case like that once. It was really interesting because, let's just say, it was the son of a esteemed public official. We'll just leave it right there. All right. Thanks for watching. We'll see you next time on Crime Talk.